Muy buenos días a todos, bienvenidos a esta primera jornada del ciclo de conferencias sobre litigios societarios. En un memorable estudio publicado hace ya casi 20 años, el profesor Luca Enríquez pasó revista a 106 decisiones del Tribunal de Milán con agudo rasero académico. Sus hallazgos causaron estupor entre los veteranos jurisconsultos de ese país. La tierra de Brunetti y Galgano y tantos otros autores citados hoy con mayor frecuencia en Colombia que en Italia, tenía a voces del profesor Enríquez un derecho de sociedades de calidad cuestionable. El problema no era tanto el contenido de las normas sustanciales italianas, ya de por sí algo anticuadas, sino más bien su defectuoso desempeño en sede judicial. Esta circunstancia obedecía en parte a que las reglas de procedimiento en disputas societarias parecían haber sido concebidas deliberadamente para ahuyentar a cualquier posible demandante. Pero el problema iba más allá de los códigos procesales. Las sentencias comprendidas en el estudio daban cuenta de un cuerpo de magistrados agresivamente formalista, desentendido por completo del impacto económico de sus decisiones y, lo que era aún más preocupante, deferente ante la expropiación de accionistas minoritarios. Aunque el estudio de Enríquez ciertamente avinagró los ánimos entre la magistratura milanesa, sus conclusiones alentaron un proceso de reforma que permitió con el paso de los años enderezar el rumbo del derecho societario en Italia. Colombia debería tomar ejemplo de esta experiencia italiana. Si bien nuestro sistema de litigio societario es decididamente de vanguardia, con un buen número de jueces y magistrados entendidos en estas materias, aquí también pueden sentirse los síntomas de la enfermedad milanesa identificada por Enríquez. Para comenzar, los empresarios que se presentan ante la justicia deben transitar por un sistema caótico y de contornos imprecisos. 12 años después de que la ley SAS introdujera la figura del abuso del voto, seguimos debatiendo si esa acción debe llevarse por la cuerda del proceso verbal o del verbal sumario, un asunto en el que las opiniones de nuestros jueces y magistrados cambian al inicio de cada ciclo lunar. Aunque en una sentencia recientísima la Corte Suprema de Justicia optó por la vía del proceso sumario, es posible que al momento de terminar esta transmisión, esa posición haya sido refutada ya por la misma Corte o incluso por algún tribunal superior, como ha ocurrido tantas veces en el pasado. Algo ciertamente más preocupante viene pasando en el caso de las medidas cautelares, un instrumento judicial que ha perdido relevancia en litigios societarios por interpretaciones agresivamente formalistas del Código General del Proceso. Atrás han quedado los tiempos en que el derecho de sociedades era terreno fértil para medidas innominadas de la más diversa índole. Hoy no es posible siquiera solicitar embargos en procesos societarios, una desafortunada restricción que ha promovido tendencias paulianas en algunos demandados. Pero tal vez la principal dolencia del sistema local sea el divorcio absoluto entre nuestras reglas procesales y los postulados económicos del derecho de sociedades. No de otra forma puede explicarse que el sistema de litigio societario colombiano tenga por característica principal un pronunciado desbalance en contra de accionistas disidentes y expropiados. Todo empieza por la legitimación en la causa. Como la mayoría de acciones legales debe dirigirse en contra de la compañía, los accionistas que controlan la administración pueden financiar su defensa con recursos sociales, una prerrogativa que, por supuesto, no está al alcance del demandante. Esta desigualdad económica suele volverse insuperable cuando se obliga al demandante a asumir los gastos, a veces astronómicos, de acudir a instancias arbitrales, aún en contra de su voluntad y hasta en las disputas más elementales. Para rematar definitivamente las esperanzas de disidentes y expropiados, sus demandas deberán prepararse casi a ciegas, con las minúsculas migajas de información que puedan obtener mediante el uso de las herramientas procesales disponibles. Y aunque algún demandante lograra sortear con éxito todos estos obstáculos, tendrá finalmente que enfrentarse a una jurisprudencia que varía en forma impredecible, dependiendo del foro al que se acude. De ahí viene entonces la necesidad apremiante de reformar nuestro régimen de litigio societario. Con esta reforma debe procurarse en esencia que los ritos procesales colombianos estén correctamente alineados hacia la solución de los problemas de agencia propios del derecho de sociedades. Dicho de otra forma, y lo decimos explícitamente, arriesgando excomunión, deben estudiarse los efectos económicos de las reglas de procedimiento vigentes para asegurar, como lo ordena el Código General del Proceso, la efectividad de los derechos reconocidos por la ley sustancial. Este será el objetivo principal del ciclo de conferencias que inicia hoy y que abarcará todo el mes de agosto. En estos foros, organizados por DLA Piper Martínez Beltrán, el Centro de Estudios de Derecho Procesal y el Instituto de Análisis Societario, académicos y practicantes de diferentes países discutirán el impacto económico de las formas procesales en el contexto de conflictos societarios. El día de hoy contaremos con la presencia de distinguidos académicos, comenzando por el profesor Luca Enríquez de la Universidad de Oxford, quien dictará la charla inaugural, seguido por el profesor Amir Licht de la Universidad de Hersliya en Israel, quien nos hablará sobre el impacto económico que ha tenido la Corte Especializada en Derechos de Sociedades de Tel Aviv. Para terminar la jornada, el profesor Larry Hammermesh de la Universidad de Pensilvania nos explicará cómo funcionan los estándares de revisión judicial en el foro societario más prestigioso del planeta, la Corte de Cancillería de Delaware. Para la segunda jornada, la próxima semana, hemos invitado litigantes internacionales que ejercen ante las cortes especializadas en Ámsterdam, Tel Aviv y Delaware para que nos ilustren con sus experiencias prácticas en esos foros. En la última sesión, el 26 de agosto, tendremos el privilegio de oír a dos de los más reputados expertos en derecho societario colombiano, Néstor Humberto Martínez y Francisco Reyes Villamizar, quienes abrirán una jornada en la que un grupo de practicantes y profesores colombianos presentará algunas ideas para una reforma del régimen de litigio societario en Colombia. Ese día también haremos un importante anuncio sobre el concurso de derecho societario organizado en este momento por la Universidad de los Andes. Y los organizadores del concurso me han permitido darles una pequeña chiva. Las fechas del concurso han sido ya definidas para el 6 y 7 de noviembre de este año. Planteado en estos términos el debate, tal vez podamos aspirar a una reforma diseñada de consumo entre nuestros expertos en derecho societario y procesal, algo que rara vez ha ocurrido en más de 2 siglos de vida republicana. Con ello será posible superar por fin aquel diagnóstico lapidario de Gavino Pinzón, posiblemente inspirado en los escritos de Roscoe Pound, según el cual el desarrollo escrito de las sociedades comerciales es menos anticuado y menos malo de lo que puede afirmarse. Sus mayores deficiencias están en los desarrollos prácticos de los principios que lo informan. No hay en el derecho societario colombiano otra tarea más urgente que esta reforma. Tengo ahora el privilegio de presentarles a Luca Enríquez, profesor titular de Derecho Societario en la Universidad de Oxford en Inglaterra. En la larga carrera profesional del profesor Enríquez debe destacarse su paso por las universidades de Bolonia y Harvard, siempre en altas plazas académicas, así como su distinguida trayectoria en el servicio público italiano. Además de comisionado de Consob, el regulador financiero de ese país, el profesor Enríquez trabajó tanto en el Ministerio de Hacienda italiano como en el Banco de Italia. Sus publicaciones, incluido el estudio sobre el Tribunal de Milán que ya hemos mencionado, se han convertido en piezas de obligatoria inclusión en currículos de derecho societario tanto en países de tradición civilista como del common law. En su discurso inaugural, el profesor Enríquez nos hablará acerca de los atributos esenciales que debe tener un sistema de justicia societaria especializada. El profesor Enríquez hablará por aproximadamente 25-30 minutos y una vez concluida su exposición, si tenemos tiempo, vamos a transmitirle al profesor Enríquez las preguntas que nuestro público haga a través de la plataforma de YouTube o que nos envíe a través de cualquiera de los medios disponibles para tal efecto. Entonces, como ya lo dije, un privilegio presentarles al profesor Luca Enríquez. Luca, welcome to Colombia. The floor is yours.
Muchas gracias, José Miguel. I really enjoyed your introduction. I cannot go on in Spanish myself. I hope you won't mind. But it was definitely flattering. And I will try to be up to the expectations that you created with your introduction by reflecting again, as you mentioned, on a topic that for me is very important, because coming from civil law jurisdictions, I have always been fascinated by the way corporate law cases are decided in Anglo-Saxon jurisdictions. At the time when I wrote that article that you cited, I was only familiar with Delaware case law. Later on in life, because I became the professor of corporate law in Oxford, I managed to get some insights into English company law and its case law, and it's very different from the US one, of course, as people will know. And it's fascinating to ask oneself how these two different regimes can still be very effective in regulating companies. My reflections today will, in a way, try and make sense of these differences in an implicit way, because I will be, and now I will try to launch the slides. I will be quite theoretical in my approach. I will theoretical, so to speak, but I will not give you examples. I will go through a talk that is really about what makes a good corporate law judge. And so in order to answer that question, one has to first ask generically what makes a good judge with no further qualification. And I think that there are three main attributes for a good judge, or four. So integrity and independence are, of course, key, as obviously the judge has to be able to master the law. And finally, a judge should aim to promote the social good while striving to do so while deciding in favor of those who deserve to prevail based on fact of the case, and striving to strike the right balance between judicial activism and deference to lawmakers' work, because we are, most of us live in a representative democracy, so it's for the parliaments to make the laws. So to be a little bit more specific, by integrity, I mean not only being in the habit of refusing bribes, but also having of oneself the perception of being ultimately a civil servant, where the emphasis is on servant and the idea that a judge provides a public service. So the role of a judge is to solve disputes, and that is a service to citizens and to organizations. And of course, in doing so, the judges exercise a power of the sovereign state. But they should always understand, and that's not something I observe, for example, in my own country of origin, where I am currently now, Italy. They should understand that exercising a power of the sovereign is not the essence of their function. It's a means, it's a tool to make it effective, but it's not the essence of the function itself. And therefore, they shouldn't see themselves as power bearers. They should see themselves as servants. And together with that, the idea of service goes the idea that the law itself, saying what the law said from judges, is the law itself is a social construct that serves society's needs and not the other way around. It's not that society serves the law or anyhow is underneath the law. It is in a sense, but the law itself is meant to help us be fairer, a richer, and better society. Independence is also very important. Judges are for sure everywhere part of the country's elite, but what I would say is that in countries where the jurisdictional function works well, judges tend to perceive themselves as part not generically of the country's elite, but part of the legal elite, and actually at the top of the legal elite, which has to be, in order to function well, somewhat separate from a country's elite to court. And so the judges' values and reputational concerns should be contained within that social sphere, meaning that they have to worry about the reputation within the legal elite, not within the elite more generally, and their values have to be those of the legal elite, which must be special in the sense that, of course, there must be an emphasis on honesty and the rule of law and being, again, independent from outside pressures. Of course, constitutional law can help to achieve that, but it's more a legal culture issue. And constitutional law and legal culture can do much to ensure the right mix of autonomy and accountability that have to shape the way judges do their job. Mastering the law, quite obvious a feature that I think implies more precisely being creative about the judge's work, which is interpretation of the law. A judge should use all accepted interpretation techniques to achieve the right outcome. And I will go back to what right means in this context later. So in addition to that, mastering the law also means, counterintuitively perhaps, not being captive to the fascination of the law as a subject. It means being aware that the law is only gets alive when applied to facts, and the better the match between the facts and the law, the better the judicial decision. Of course, this is costly, and so legal proceedings are very costly in countries where jurisdiction works well. But I think that is less of a problem for corporate litigation, of course, but it's something that lawmakers should have in mind when deciding civil procedures rules and all access to justice rules, of course. Finally, mastering the law and their own functions means being very careful about how they make law, which they do, as I will say in a second. They make law by interpreting the law, and they have to be very careful in writing the holding of their decision, because they must be aware that de jure or de facto a decision has a value as a precedent, and the wider the precedent, the greater the impact, and it might be a difficult exercise deciding how broad a precedent should be. Well, and then the most difficult part, which is what it means to promote the social good. As I said, we can't be naive about separation of powers. Judges inevitably themselves make laws. They are also social engineers or a particular kind of politicians because they allocate goods throughout society with their decisions. And we shouldn't be blind about that. So what ultimate values and social goals guide them is extremely relevant. And the laws and even the constitutions, of course, give them some guidance on what their social goals should be in exercising their functions. But it is always, or it is often at least, incomplete or insufficient guidance. There's always some room for maneuvering, whether because the law is not entirely clear or because the law explicitly or implicitly allows for different goals to be pursued in the interpretation of a given rule as the rationale for the rule. So there is some rule for residual, quote-unquote, social goals that judges are allowed or perhaps well advised to consider when they make decisions. Although, of course, these tend to be sector-specific, so I will come back to this when I deal specifically with corporate law. And going back to this idea that they have to thread carefully in trying to decide individual cases in the right way, it is important for courts, of course, to decide rightly on an individual case, in a rightly meaning in a way that here that promotes social good, because this will legitimize a court's function. And but still at the same time, and this is something British judges are especially conscious of, aware of, legal certainty also is important and similarly contributes to legitimizing courts. So it's important to have in mind that precedents do matter. The Latins used to say, or someone for them later, that in claris non fit interpretatio. In civil law countries, we tend to think that this hardly matters, but still one has to be aware that one cannot completely disregard the wording of the law because we live in democracies, and while parliaments are not always careful in the choice of words, still what they say has to matter democratically. And but still there might be there is a broad area which is more or less gray where judges can exercise their legal creativity and come up with better solutions for the individual case. And of course, in civil law jurisdictions, this is perhaps counterintuitive, but I think all of you who come from civil law jurisdictions will find this familiar. The tendency is, in fact, for judges to be quite a lot, to have quite a lot of leeway in providing interpretations that do not necessarily conform with the letter of the law. I think that's good in some cases, but it's something that should not be abused or used too liberally. So the idea is that a balance should be struck between these two competing constraints, and that should be done by focusing the judge's attention on the facts and shaping the ruling, the holding around those facts. What about corporate law judges more specifically? So here I used a strange meaning for integrity. Of course, I take honesty for granted, but by integrity, I meant the idea of serving society and not the other way around, not thinking that one is at the top of society and has to be served by lawyers, by citizens, and so on. And so that means also understanding the functional nature of the law, and specifically understanding the functional nature of corporate law, which in turn implies, and in the country where I come from, Italy, that's not definitely obvious, accepting that we live in a market economy and markets drive the economy. Exchange is the basis for how the economy works, and at least some degree of deference should be given to contracts, basically, and exchange, because the presumption should be, and I say, of course, it's a winnable presumption, but the presumption should be that if two parties enter into a contract, it means that they think that the contract makes them better off. And so it's not a zero or a negative sum game. And of course, and this is the most obvious thing I will say today, I hope economic literacy obviously helps. Knowing something about economics is a must for a corporate law judge to do her job well. What about independence? Here it's tricky because the smaller, let's say, economically and physically a country is, and the smaller its elite as a consequence is, the harder it is to compartmentalize the legal elite, which means that judges will be less free of pressures from the outside. And in the corporate law context, these outside pressures come from two sources. One is politics, and that will be especially the case when there is a mixed economy and some corporations are controlled by the state, but it can also be the controlling shareholders, which are prevalent in most jurisdictions. So there is a risk of capture for judges on the part of powerful insiders. That is, as I will argue later, bad. What can be used to counter these risk of pressure from the outside? Well, one may hope that, and one may posit actually, that if the relevant judge has a sense of mission, thinks that what they are doing is important for the economy and has to be guarded as an important economic function, then the outside pressure should be lower. That means that being a special purpose court, possibly a specialized corporate law court, may help. And we may see, in a way, Delaware as an example of this, because Delaware is a small state, but it serves a much wider market than Delaware, and it is certainly clear that Delaware judges have a very strong sense of mission. What about mastering the law? There is the old saw that repetition is the key to success. This is true also for corporate law judges. If they want to decide cases well, they have to have a heavy case law. They have to repeatedly decide corporate law cases. The more they decide, the better. Because there will be it will not be always the same people. There should be a panel of judges, not individual judges deciding cases, so that more experience goes into the mix and in any decision. And of course, it is important, and nowadays almost everywhere the case that cases are easily available, easy to know, and easily made available to the public, to lawyers, and so on. Mastering the law also implies understanding the effects of the law and individual holdings on people's behavior. Again, given the fact that the law, de jure or de facto, everywhere has value as a precedent, the case law, judicial decisions. So judges, when deciding an individual case, should, I think, ask themselves what implications there will be if people will follow the dictum, will adapt to what the law requires them to do. But also that means being aware that because people tend to avoid constraints that may be harmful to their welfare, then it will be rational for people to adapt in the wrong way to the dictum, that is, engage in regulatory arbitrage, avoidance strategies, and so on. And so in shaping a dictum, a holding, judges should make these sort of considerations, and on the one hand, and given all the constraints of the case, of course, provide for dicta that holdings that will lead to the right behavior, but at the same time that will minimize the risk of regulatory arbitrage or avoidance. And of course, this implies, again, exposure knowledge of economics and finance. One needs not be an economist or a financial economist to be a judge, but core intuitions from economics and finance will definitely help a judge give better judgments. Third point here, doctrinalism should be seen as a tool, not the only tool, not a name for sure in itself. It shouldn't be the end of the story. And actually, one may even argue, and I did that in my article almost 20 years ago, that there could be some form of functional doctrinalism. What I mean by that is that doctrinalism is so rich, we have to recognize that, and allows for so much creativity that a good judge will be good enough to choose the right line of argument and the right construction of the law in order to reach the right outcome and make it more acceptable also to the legal community as a whole. So we should treat doctrinalism the same way as Karl Kraus depicted prejudice a while ago. He said prejudice is an indispensable butler who keeps annoying impressions from entering our house, but we must avoid being thrown out of the house by our own butler. So, of course, in order for judges to perform this kind of role and do these sort of things, it is important that the way they do it is accepted by the broader legal community. So lawyers themselves have to specialize, and the richer accountant, the likelier that it is the case, that's the case. But also they should be educated to share the same functionalist view of corporate law, which leads to the third leg, so to speak, for safe, healthy legal culture, which is academia, which should similarly be open-minded in terms of what the function of the law is and what corporate law is meant to achieve, which is what I turn to now in my last 5 minutes or so. Of course, there might be legislations, even corporate law statutes that clearly identify social goals other than social welfare for corporate law. But when that is not the case, when these different social goals are not clearly identifiable, then corporate law should be thought as thriving to facilitate economic activity, facilitate growth, and it's not about a redistribution, as Easterbrook and Fischel wrote in their book by now almost 30 years ago. So the judges should be able to consider, whether explicitly or implicitly, but I would say also explicitly, the overall welfare effects of the legal interpretation that they give. And again, this implies having a good understanding, at least basic understanding, of economics and finance. What does that mean more specifically? People, the basic assumptions that underlie economics and what may be sufficient to know about it for a judge is that people are or tend to be rational and minimize the negative effects of laws and other constraints on them. So judges should know that and avoid incentivizing avoidance with non-functional interpretations where possible, for example. So if you say that a phenomenon X is prohibited, but you can achieve the same outcome as X with Y, perhaps as a judge you should think twice about how you shape that prohibition, so as not to provide an incentive for people to do Y. That's something that could be done. Corporations, the other quite generic but important insight from economics and finance is that corporations are effective tools to finance economic activities. That's pretty obvious. Schumpeter said that long ago. And so rules that lower financing costs without externalizing them will be good, because what outside financiers get is what is left following management by controllers, preventing controllers from managing in a way that is akin to stealing is intuitively wrong. So emphasis should be given to how punish and therefore prevent stealing on the part of controllers. But at the same time, judges should be aware that the controller's power is not negative per se, and therefore, when needed, it may itself deserve some protection. And in order to an understanding of the underlying economics and finance that is behind any economic decision, and therefore also behind any corporate decision, is also necessary to get the facts right. For example, bad judges tend to be unable to second guess expert opinions, for example, about valuation, whereas a good judge should, when needed, try and form his or her own opinion about two contrasting expert opinion, for example, about the valuation of a company, an asset, etc. They should also be able to understand the underlying business rationales of a transaction anytime the business judgment rule doesn't apply, which is basically when violations of the duty of loyalty are brought to the foreground. And so this is very important. Getting facts right allows for greater fact specificity, which in turn allows for greater justice of the individual case while adapting the precedent value of the individual decision. That is, there might be an individual situation where the plaintiff deserves winning, but perhaps the law has to be tweaked a little bit in order to make her win. A good judge will make sure that the holding that comes from that decision will be extremely narrow. And finally, an understanding of the underlying economics and finance will help using what Delaware practitioners used to call the smell test within the boundaries of statutory law. What is the smell test? It's the idea that a judge should be able to understand when there is something wrong in a transaction and basically find ways to strike it down whenever it stinks badly enough. The last slide is just a summary, so maybe I spoke enough, and I will leave you the slide for a second, and thank you very much for your attention.
Thank you, Luca, for that wonderful presentation. We actually have a couple of questions from your audience. If we can take some minutes from your time.
Oh, sure, but it's Amir's time, not mine. Also Amir's time.
Well, he starts in 3 minutes, so we have, I mean, like room for 1 or 2 questions. I'll try to translate. So there's one here about something you included in one of your slides. You said judges should be creative in order to achieve the right outcome. But some economists say that the civil law judge's toolbox is more limited. So here's the question. Do you think that judges in civil law jurisdictions are more constrained to be creative than their common law counterparts?
No, actually, no. As I hinted during my presentation, I think it's quite the opposite. If you take one of the most famous German cases, the Holzmüller case, the one that says that, that there are limits to the freedom to contribute assets to a subsidiary in order to protect the rights of minority shareholders in the parent company. And you see how the judges reached that conclusion. Basically, they say it's the natural. Basically they say we don't need to find a justification in the statute. We as judges have the power to do that. And my impression, so that's an example, but and of course I'm more familiar with the Italian law than any other law. But what I see is that when judges have the motivation to be creative, they have absolutely no hesitation to come up with solutions that are absolutely counterintuitive. And my guess, from the little I know about Latin America, is that is the case there as well. Well, may be the wrong example, but Brazil for sure has very activist judges in all areas, including corporate law. The little I know about Colombia is that the judiciary there is very powerful, and I would be surprised if there were no ways of using one of the many interpretation tools to achieve the outcome that for the specific case is the best one.
Thank you, Luca, for that answer. We actually have a number of questions, but we ran out of time. So I'll send them your way via email. And I thank you once again for joining this conference. And now I'll introduce Amir. So take care, Luca. Nice seeing you.
Nice seeing you. Bye-bye.
Amir, are you online?
I'm here.
Oh.
Hi there.
Hi. Bueno, vamos a continuar entonces con la participación del profesor Amir Licht. Amir es profesor de Derecho Societario y Regulación del Mercado de Capitales en la Universidad de Hersliya en Tel Aviv, en la que también ocupó por algunos años el cargo de decano. El profesor Licht ha sido asesor del regulador bursátil y del Ministerio de Justicia en Israel. Es uno de los principales expertos israelíes en materia societaria, con aclamadas publicaciones sobre conflictos entre accionistas, gobierno corporativo y el impacto de factores culturales en la conducta de los administradores de sociedades abiertas. El profesor Licht nos va a hablar hoy acerca del funcionamiento de la Corte Especializada Societaria de Tel Aviv, una de apenas 4 cortes societarias especializadas en el planeta: Delaware, Tel Aviv, Ámsterdam y Colombia. Son los únicos lugares que tienen cortes de esta naturaleza, y por eso le hemos pedido al profesor Licht que nos hable brevemente acerca de cómo funciona este foro en Tel Aviv y qué impacto ha tenido en Israel. Professor Licht, welcome to Colombia. The floor is yours. At the end of your talk, we'll probably send some questions your way, and you have half an hour. Thank you for joining us.
Thank you very much, Professor Mendoza. Thank you for the kind invitation. Let me share my slides. Just a moment. Right. Okay. Can you see my slides now?
Yes.
Yes. Perfect. So again, thank you for the invitation. I plan to leave some time for questions at the end. I hope we'll do well. The time will be enough. So I'm going to tell you a little bit about the story of the economic division of the Tel Aviv District Court, one of the few, as Professor Mendoza mentioned, specialized corporate courts around the world. So I think you know by now that there's like a fad or a lot of enthusiasm about business courts and specialized courts. They're all the rage. We know of them in many countries around the world. In most cases, they are specialized commercial courts or business-oriented courts. But as already was mentioned, in a few countries, Colombia and Israel are among them, there are specialized corporate or corporate securities courts. But clearly the leader beyond dispute is the court that we see here, the Chancery of Delaware. And the Chancery of Delaware, as Professor Enriquez also mentioned, it's pretty much an agreement, is admired, even worshipped among lawyers and business people. We turn to the Chancery of Delaware like it was the Mecca of corporate law, also in not just the substantive law, but also the adjudication. And what really is special, and is not in dispute about the Chancery and the Delaware court system, it combines high quality of lawmaking, justice making, administration of justice, adjudication, high volume, a lot of decisions, big transactions, also economic volume, and very high speed. I mean, the Chancellor of Delaware and the Vice Chancellor turn around massive cases within days. So this is like the model of a specialized corporate system. What about the Israeli experience? That's the topic of my presentation. We talk about basically a division, a part of the Tel Aviv District Court that was established or defined 10 years ago, in 2010. And this is, if I kind of can just summarize it, this is a story about a well-intentioned reform that went wrong. And the reason why it went wrong, at least to my mind, is because too many people were blinded by the Delaware appellation. And that's a lesson I would like to kind of examine or investigate during my presentation. If we are to summarize the bottom line of this 10-year experience that is still going on, turned out to be very good for lawyers. It is questionable in my mind, or at least arguable, debatable, whether it was good for business, which is the constituency that we are to serve. We have to begin it with a prehistory. And in our case, the prehistory begins in 1917. This is when Great Britain, towards the end of World War I, conquered Palestine. You can see here in the picture, that's like an iconic image. You can see General Allenby, the commander of the British forces, entering the old city of Jerusalem. Jerusalem surrenders. Before 1917, for 400 years, Palestine was ruled by the Ottoman Republic, by the Turks. But what followed is a period between 1922 and 1948 when Palestine was ruled by the British Empire, but not as a colony, but under a mandate from the League of Nations. The mandate was to establish a national home for the Jewish people. However, the British treated Palestine like any other colony. I mean, they managed the country like they did with the rest of their territories. And one of the first things that they did, and continued doing throughout their rule, was to establish a common law system in the country. And that system consists of primarily a court system. So we are talking about a unified system of common law and equity, joint jurisdiction in terms of the court authority, a system that operates according to the principle of binding precedent, and crucially for the lawyers among you in the audience, also followed English civil procedure. So the whole spirit, the legal culture of the system became gradually very English, very common lawish. In terms of substance, they also gradually kind of replaced the entire substantive law of the country with what you can think of as a codified version of the common law. So the British Empire had like sets of statutes and prepared sets of statutes that codified case law, English case law. So we got a company statute and a tort statute and a criminal law statute and so on and so forth. Basically a set of UK law during the 1920s, 1930s until the 40s. And in addition to that, it's not just that the country lived with those statutes. There was a constant reference to English case law as it developed during that time. So it was like a satellite system of the British common law system and the law itself. The formative years of Israel begin in 1948 when the State of Israel is established. And one of the very first things that the country did, the new country did, like within minutes since its establishment, was to pass a law that said the pre-existing law remained in force, including civil law, including private law, that is. But the first decades, we're talking the 50s and the early 60s, were years when the country faced major security and economic challenges. I mean, you can see here in the picture, those were austerity years, post-war, and especially for a small country like Israel at the time. For our purposes, that meant that commercial law and corporate law was litigated at a very, very low volume. But amazingly enough, what did come out from the courts in those early decades was great stuff. I mean, when I look back at those decisions, how they handle complex corporate cases, not necessarily big transactions, but difficult legal issues, was very admirable. And the reason why that could happen is, again, echoes things that that Professor Enriquez has mentioned, and I will get back to in a way. We didn't coordinate, so I was happy to listen to his lecture and see that he's kind of preparing the grounds. Education, legal education, mastering the law that was relevant for adjudicating corporate cases, corporate disputes. The country developed until the 80s. I mean, the big turning point that is important for our purposes is the mid to late 80s. It's a period of economic growth. Commercial law develops in parallel. And during that time, there's a regular reference to English law. So again, there was a lot of, I can't say bilateral exchange, because, you know, English judges don't read Hebrew. Legal system in Israel goes on, lives its life in Hebrew, but there was a lot of reference and a lot of importation from English law. So by the mid to late 80s, Israeli corporate law had all the major features of any English influenced company law systems. So that would be like the UK, Australia, Canada, New Zealand, and stuff like that. So we're talking about a very developed body about the duty of loyalty, a decent set of rules about the duty of care as we know it in the business context, meaning a doctrine that is roughly equivalent to the business judgment rule, not the Delawarean business judgment rule, but something quite along these lines. A well-developed body about oppression. So this is the major doctrine that serves to regulate abusive power by controlling shareholders. And oppression of the minority is the old doctrine. It was replaced in the 80s in the UK and shortly thereafter also in Israel with a kind of a more modern, more flexible, but essentially equivalent doctrine of unfair prejudice. Again, regulating the power or regulating abusive power by controlling shareholders, and crucially for adjudication, derivative actions. So as you know, the big challenge in corporate law is how can you take the insiders, the powerful insiders, be they managers or controlling shareholders, how you take them to court, how you bring them to justice. And the answer that the common law system, primarily the English system, has developed is the derivative action. And Israel followed the same body of law and the same doctrine developed in Israel. What we didn't have until pretty late, until the late 80s, was class actions. Again, that was a consequence of our UK heritage. UK law doesn't like class actions. It doesn't have class actions to this day. In fact, there's some substitute that was developed just recently. So this, as you can understand, this puts a hurdle to any kind of mass torts, including securities litigation. So, like, to summarize the body of law at the 80s, turning into the early 90s, substantive law was in very good shape. But because there was relatively low litigation volume, we had like seminal cases and major principles, but not a lot of detailed rulings, and virtually no securities litigation and virtually no securities law to speak of at the time. Now comes the big leap. Between the 1990s and the 2000s, the Israeli economy and the Israeli market economy developed very rapidly. The stock market grew very substantially, and probably the most important economic development was the emergence of the high-tech sector, and it boomed. It boomed in a very important way. There were big transactions by that time, a lot of international investment flowing into private companies, and an important development that also kind of bears on our topic was that literally dozens, we're talking about dozens of Israeli companies that went to the NASDAQ and listed, mostly the NASDAQ and New York Stock Exchange, listed their shares on American markets, and kind of created a bridge and a channel of influence from the US, primarily in terms of securities regulation law, but also in terms of opening to Delaware law, to corporate law. Also, in the late 90s, mid 90s, through legislation, a mechanism of securities class action was introduced, but they were relatively few at that time. They grew in number only later. The courts, however, were slow to develop to respond to these developments, and now you can see the seeds where the seeds for the development of the establishment of the economic division were sown. Those proceedings, that litigation that did take place, tended to be lengthy. We're talking about many months and usually a good number of years. Like the most famous securities class action litigation overall took some 15 years to resolve, and you know, a couple of years was like the average time for a corporate case to litigate, and that created some frustration. Now, probably, and this is my interpretation, but I think most people would agree with that, the most important factor that pushed for the establishment of the specialized court was actually the securities authority. It was the government and the specialized securities regulator that I can say, I mean, I teach securities regulation, and they suffered a number of embarrassing setbacks during the 1990s and early 2000s. Clearly silly mistakes by inexperienced judges. Not that many. But upsetting for a securities regulator with an ethos of professionalism. So there was a sense of frustration also in the government with the performance of the Tel Aviv District Court, which is, you know, most of the economic activity in Israel concentrates in the Tel Aviv region, the greater Tel Aviv region. So the Tel Aviv District Court pretty much dominates business litigation. At the same time, because the statute, the company statutes by the late 90s was like 70 years old. It was introduced by the British rulers in 1929, was amended a number of times, it's not modernized. There were many calls from the business sector to modernize. And to have judges with more business expertise. And in general, people said, be like Delaware. Let us be like Delaware. Look at Delaware, see how they do it, and let's do it. Let's do the same over here. Now, here in parentheses, you can see. I mean, you don't have to be cynical to be suspicious. So there are always private interests. They cannot be ignored. One can tell a story of, in a public choice kind of story, how, well-organized business groups or interest groups shape or affect the development of the law. I can't prove that. I have my own theories. These are not conspiracy theories. These are, ideas about people who are, or sectors who have an interest in certain developments in the law. Keep that in mind, okay? This came up also in Professor Anikis's lecture, and it cannot be ignored. The big event was in 2010 when the economic division of the Tel Aviv District Court was established. I mean, it's not a new court, right? It's just a division within the district court that oversees all of the litigation in the district. Basically, three promising, brighter than average, but not, the best, not necessarily the best and brightest, but clearly promising judges were identified, and they were allocated to this new division. And that division, through a legal amendment in the, basically civil procedure statute, had jurisdiction over corporate and securities cases, including criminal securities cases. I mean, public enforcement of the securities law. And the idea was that these three judges will specialize, will gain expertise, They will become more familiar with, financial economics of big transactions and so on. All the issues that Professor Enriquez also mentioned, and the media celebrated. You can see here in quotation marks, from Delaware to Tel Aviv. So Delaware was the model, the thing to be followed, the example to be followed. At the same time, an unrelated development, but took place at the same time, because there was a lot of, the caseload in the Tel Aviv district was very heavy. Another district was established. It's called the Central District Court, with overlapping territorial jurisdiction. So there was like competition. You could choose where to file, whether in the Tel Aviv District Court, like a corporate or securities case, and that would go to the economic division, the specialized panel, the specialized court, or you could file to the Central District Court. And then what would likely happen, and did happen, is that basically two judges, one of them exceptionally brilliant, now sits at the Supreme Court, another one very experienced, kind of a seasoned common law judge, and they, not by design, but by coincidence, serve as a control group for the economic division. What happened? How am I on time? Okay. In terms of performance, technical, rough, dry numbers, by impression, if you ask, the lay business person who, is familiar with the issues, the business community is happy. There is the image, the public image that, businesses served. We have like expert judges who sit and dispense, justice in complex cases. The media in particular is happy about the economic division. So they have a very good, very positive public image. When you look at the numbers more carefully, the picture is more balanced, I should say. There's a study by Yifat Aran, a Stanford Law graduate, that was done in 2016. So it was done after 5 years. That's a caveat, but this is what we have. It's a very careful study about, the development of cases in the economic division. And what she found is that essentially cases took about the same time as before. So there was not much of change in comparison to the period before the specialized court or the specialized division was established, and also roughly similar to the quote-unquote control group, the central district. Why? How come? What she offers as an explanation, I think it's very convincing, at least to me, is like a simple economic mechanism in place. So there was an increase in the supply of adjudication services, which comes, is followed quite quickly with an increase in the demand for litigation services. And the whole system ends up in roughly the same equilibrium price if you think about litigation costs as the equilibrium price. So it's like the government building a new road. Quite quickly, people understand that there's a broader road, so they buy more new cars, and you end up getting stuck in the morning traffic just as you did before the new road was built. This is basically the same story. So this moves us, should shift our attention to the question of quality. Did quality improve? And here I would like to put the argument, and I'm sad. I regret that I have to put it like that, but that's my view. That substantive law, the quality of the law, actually deteriorated in several core issues. Now, when I prepared this presentation, I debated how much I want to get you into the detail. I decided I'm not going to get you into any doctrinal details of Israeli law, so I'll just refer to some headlines. So when you look at the core, the central tenet of company law, and we think about the duty of loyalty, basically the economic division, the specialized court, did away with a fundamental principle of fiduciary law, which is fully informed consent. That's FIC there, fully informed. A breach of a fiduciary can be excused only through fully informed consent. And they did away with that. What came in lieu of that? The division adopted something that was purported to be a version of the standards of review of the Delaware law, about which we will hear from Professor Hammermesh. But I put these, between quotation marks because I regret to say, I'm afraid to say that Professor Hammermesh may not recognize the way the Israeli specialized court kind of talks about the standards of review. Also, they gave wrong remedies. So these are doctrinal mistakes that shouldn't be there. Okay, shouldn't have happened. There are problems also with the adjudication of duty of care cases. On the one hand, the division kind of introduced to Israeli law the business judgment rule, again, with a strong Delaware influence. But here, again, as I mentioned, we already had a version, actually a legislative version of a business judgment rule. And at the same time, a court that was supposed to be imitating Delaware was doing substantive review of business decision. That's a no-no. Let me, for the interest of time, let me skip the special litigation committees. That's another story. But what is important is that in many cases, the specialized court invokes Delaware law. This is how it's done in Delaware. We're going to do the same. This is how the Delawareans do that. We're going to do the same. Notwithstanding the fact that in certain cases, the Israeli legislation, the statutes, says something different, and quite, every once in a while, established principles of English law in Israeli law say something different, and maybe even in Delaware. A disturbing feature of this trend or this development is that the Supreme Court tend actually to defer to the district court. So the higher instance in the system actually gives a lot of deference to the specialized court, and that's a big question why. In summary, corporate law, I think, even if you don't buy into this, better or worse, became more confused. Corporate law after 10 years became much more confused. So there's more rather than less litigation, and surely the lawyers are happy, but I'm not sure that business people should be happy. Let me summarize with some brief lessons, some insights. Again, these are my views. You could hear other views. The first is maybe obvious, but it does have force here. There's no silver bullet. If you want to kind of upgrade your corporate law corporate adjudication or corporate cases adjudication, there's no quick fix through some, let's establish a little court and they will do just that. In fact, the Israeli experience tells you that things can actually get worse. And you have to be very careful about that. And here it's important for me to emphasize that all of that was very, very well intentioned. I mean, the court system in Israeli is very clean, in terms of absence of corruption. Local government may not be that clean, but the court system is at a very high level of integrity. So this is done for good reasons, so to speak. Another lesson, imitation is difficult. I mean, you want to follow the leader, you want to learn from the experience of the leaders. You can adopt, including from Delaware, but you'll have to adapt according to the local needs. So the example that I give to my students usually is that it's very difficult. It's hard to upgrade a non-US car with US car parts. So suppose we have a nice, a Jaguar car from the 80s that's still running well, but could use some upgrades. You're not going to do anything good if you use car parts from a Chevy Corvette. Like a Chevy Corvette is a fine car, but its parts don't, interact well with the old English cars. So there's a way to do that. A lot is needed. And I'll finish with a point that Professor Enriquez mentioned more than once. Mastering the law is key. It takes a lot of legal education, not just the judges, but the entire legal community, to be able to argue cases, to design transactions in a way that would be litigated later on, in a way that is consistent with the way you want the law to operate. That's it. Do we have time for questions?
Thank you so much, Amir. That was extremely interesting. We actually have a couple of questions, but only 1 minute before Larry's set to start. So I'll just pick one question randomly. Let me check it. Okay, here's one. Do you think that there should also be a specialized court of appeals above the economic district court? And I'll complement it. Do you think that might be a remedy to correct some of these deficiencies you have noted in the decision-making process and the presence of the economic division?
That's a very good question. There's not a good reason to bypass the Supreme Court. I think the key point here is to keep studying the law, regaining the expertise that was in existence. That's the big mystery. Let me remind you, the early judges were true experts in company law. The kind of expertise that you see today among English judges. So I would not kind of bypass or replace the Supreme Court. And despite like the like gloomy atmosphere of my presentation, I'm actually optimistic. I mean, that's the power of a common law system. It has this tendency to correct its own mistakes. So I think that over time, people will realize that Delaware is fantastic, but you need to use these like U.S. car parts in a way that is consistent and compatible with the working of a legal system that is primarily English structured.
Fantastic, Amir. Thank you once again for your time. Now we're very pleased to welcome Professor Larry Hammermesh. Larry, nice to see you again.
Delighted to see you.
Oh, sorry. I'm going to make a short introduction.
Go right ahead.
And then just hand it over to you. Muy bien. Vamos a seguir ahora con el profesor Larry Hammermesh. El profesor Hammermesh es el director ejecutivo del Centro de Estudios en Derecho y Economía de la Universidad de Pensilvania y profesor emérito de la Universidad de Widener en Delaware. Desde el año 1995, el profesor Hammermesh ha formado parte de la Comisión de Reforma Legal del Estado de Delaware, el cuerpo colegiado que tiene a su cargo la curaduría del sistema societario más sofisticado del planeta. Como lo mencionaron hace algún rato, las leyes en Delaware se actualizan todos los años. Es un proceso constante, gradual de mejora legislativa. El profesor Hammermesh ha estado en el centro de ese proceso desde el año 1995. También ha participado en la preparación de las leyes modelo en materia societaria que publica la Asociación de Abogados Estadounidenses. Por último, y conociendo a Larry, tal vez lo más importante para él, el profesor Hammermesh es miembro de la Junta Directiva de la Escuela de Música de Delaware. Nos va a hablar hoy el profesor Hammermesh acerca de los estándares de revisión judicial que usa la Corte de Cancillería de Delaware para saber qué operaciones con accionistas controlantes son buenas y cuáles son malas. Welcome, Larry, to what I believe is your third time in Colombia.
It is, and it's a pleasure to work with you again, Jose Miguel. It's also a great honor to follow, and maybe a burden to follow two such distinguished scholars as Professor Enriquez and Professor Licht, both of whom seem to know as much about Delaware as I do, plus a lot more. But I'll see if I can add anything to their very compelling presentations. To get that going, I'm going to try to share my screen. Not having luck with that right now. Does that work, by the way, Jose Miguel?
We can't see it yet, but we have time for you to keep trying. So.
All right. I am clicking on the share.
Yeah.
button on my screen, but don't see a good place to go from there.
Right. If you maximize your PowerPoint slide, so
Yes.
Just bring it up. And now try share again.
All right. Say something when if it comes up.
Yeah.
We good?
Nope.
Any luck yet?
Nope.
No.
You'll hear me screaming in joy when it comes up.
I'm terribly sorry.
No, don't worry about it. It's.
Well, I'm not going to waste people's time any further, and I'm very sorry not to be able to share the slides, but I'll try to talk slowly enough so that they'll be understandable, and I'm happy to forward them to anybody who wants to see them.
Larry, if you want, I can share them for you, and if you give me instructions, I'll change the slide.
That would be good too.
Yeah, let me do that, but you can just start talking. Go ahead.
Sure. And the first slide, when it comes up, is something I rarely do as a law professor, which is get to the point right away and tell you what I really am trying to get across. All of the presentations this morning are about the mechanisms for enforcing corporate law in a way that is socially productive. My central claim is that and you can move to the next slide, is that the enforcement of corporate law is a public good that promotes commercial predictability. It enables people to plan and to do so in a way that is consistent with overall value maximizing behavior. It depends, however, on being able to make the world aware, or at least the relevant part of the world aware of the rules and how they're enforced so as to guide future business conduct. And as a result, I maintain that public enforcement of corporate law deserves public support, as we've seen in Israel and in Colombia, for that matter. In Delaware, it has an interesting source of public support. Delaware is just one and very small state, but corporations that establish themselves in Delaware are required to pay what's called a franchise tax, which varies largely according to the size of the company, but in the larger corporations, comes to, I think, on the order of $250,000 US dollars a year. And that fund makes up a substantial part of the state's budget and supports this mechanism, this institution for public enforcement of corporate law. So the next slide is just a very brief review of what corporate law actually enforces. So if you'll move to the next slide, you'll see that we're talking about enforcement of the obligations from whatever source, principally common law, of corporate directors, officers, and controlling stockholders. And in practice, this is largely the duty of loyalty and has its greatest impact in regard to related party transactions. In the United States, this is oddly simply a matter of state law, and there are 50 states plus the District of Columbia that each have their own corporate law. But Delaware's is, as has been said, the dominant body of law in the United States. And the duty of loyalty is entirely the creature of judicial imagination and application. In Delaware, at least, there is no statutory foundation for the duty of loyalty. It's purely a common law creation. And as applied, and Professor Licht referred to this, there are various levels of intensity with which Delaware judges will look at challenged transactions. The baseline, the default, if you will, is the business judgment rule, which in Delaware simply means that if there is a product or a transaction that is the product of ordinary director approval, then any rational justification will validate the transaction, which basically makes it impossible to challenge in litigation and results in typically throwing out the case before any great amount is spent on discovery and other litigation practice, let alone trial. So a very deferential standard. And at the other end of the spectrum is the most intensive level of scrutiny, which in Delaware is called entire fairness review. And that's a scrutiny that's reserved for transactions which are the product of decision makers who suffer from a conflict of interest, where that conflict of interest has not been overcome and the transaction has not been validated by independent and disinterested corporate actors. In entire fairness review, the person who is defending a transaction bears the burden of demonstrating that it's fair in all of its aspects, procedural and economic. And when that standard of review, that intensive level of scrutiny applies, full trial and discovery and all the expense that Professor Enriquez referred to is necessary. There's also a considerable level of uncertainty, which means as a bottom line that nobody wants to be in that soup. And there is a very strong incentive to avoid entire fairness review. So who does this enforcement? Next slide will show you that, as you know, it's the Court of Chancery. There is an appellate court that supervises the Court of Chancery. It's our Delaware Supreme Court. But the Court of Chancery is on the front line. It's the trial court that sees and decides most of these cases. It is a very odd institution, a historical anachronism, really. There was a period in England going back 400 or 500 years where there were separate law courts and separate equity courts. And that system was transported to then the colonies, became the United States. And most states abandoned that separation in the early 1800s. Delaware, for reasons that I actually don't even know, kept it. But it was a fortuitous, very happy accident that Delaware did that, because the Court of Chancery has become critical in establishing the reputation that Professor Enriquez and Professor Licht were so generous in discussing. And so I thought I would touch for a few minutes in the next slide about why the Court of Chancery has been as successful as it has been. Professor Enriquez very prudently and perceptively anticipated the first one. As a court of equity, historically, the Court of Chancery has had a very limited scope of jurisdiction. It handles corporate cases and it handles trust cases and guardianships. But basically, it handles cases that have some fiduciary content, where there is fiduciary conduct to be evaluated. Doesn't handle criminal cases at all. Doesn't handle ordinary tort cases, debt collection cases, and therefore has a very concentrated body of cases on its docket. The result is specialization, and that specialization exposes the members of the Court of Chancery to a rich diet of business law education. and experience. And as Professor Enriquez correctly observed, that's been an important reason for the court's ability to handle cases as expeditiously and sensibly as it has. And by the way, I don't agree with every ruling of the Court of Chancery, nor do I agree with every ruling of the Delaware Supreme Court, and they don't always agree with each other. But on balance, they do a pretty good job. One of the contributors to the predictability, the predictive value of litigation in the Court of Chancery is that, unlike many courts in the United States, there is no jury. That's part of the historical accident of its heritage from England. There is no jury, so the decision-making doesn't go into an impregnable black box whose reasoning you can't really see. There are also no punitive damages allowed in the Court of Chancery, again, that drawing on its equity history, and that contributes to a great deal of the comfort level on the part of business participants with the court. Another element, really interesting one at the moment, is one that doesn't go quite as far back, but in the late 1800s, the Delaware General Assembly adopted a provision that requires that the members of the Court of Chancery, and I'm simplifying a little bit, but that the members of the Court of Chancery be no more than a majority from one political party and the remainder being from the other political party. And as I'm sure you all hear, with Democrats and Republicans being at each other's throats these days, the idea of enforcing political balance is an interesting choice, and it does contribute to the independence of the Court of Chancery and its members in ways that Professor Enriquez suggested. There is currently a case that's going to be heard on October 5th in the United States Supreme Court challenging the constitutionality of that political balance requirement. And so far, the lower courts have invalidated it as an improper political requirement. One of the exceptions to the rule that prohibits that kind of political requirement is a rule that says that if the officer in question is one who serves a political or policy-making function, then that political balance or political tests are appropriate. So it's very interesting for me to hear Professor Enriquez talk about judges correctly, I think, as having a policy-making role. And honestly, I expect that the U.S. Supreme Court will reverse and reinstate and validate this balance requirement. But I'm not always very good at predicting judicial outcomes, so we'll see. The next element of the Court of Chancery's success is what I call its public-facing character. It invariably decides cases through reasoned opinions, and most often they are written opinions. So the whole world can see what the court is thinking and why the court reached the decision it did. That alone compares favorably to the sort of confidential world of arbitration, where you don't necessarily even hear the outcome, let alone find out why an outcome was reached. Another thing that Professor Enriquez mentioned that's relevant here is the sense of mission that members of the Delaware Court of Chancery feel. They are stewards. They perceive themselves as having a stewardship responsibility, and as a result, they participate actively in public discourse with bar association programs, with continuing legal education programs, writing and law reviews. And again, this compares differently with arbitrators who largely function quietly and confidentially, sometimes for good reasons, but it's a very different system. And the last reason for the Court of Chancery's success is one of those car parts, to use Professor Licht's very nice analogy, that's hard to transplant, and that is a private enforcement infrastructure with incentives that will drive cases in appropriate directions. There is a very well-developed class and derivative plaintiffs bar, institutional plaintiffs bar, that has a very significant presence in Delaware. And the carrot that moves the horse forward is the prospect of an award of fees in the event of a successful recovery. The Delaware courts can be very generous in awarding fees. The most well-known fee award was won, say, about 6 or 7 years ago in a class action, or rather a derivative suit, in which the recovery was about $2 billion, and the fee award was a little over $300 million. I know some of the people involved in that case, and they still are very generous contributors to some of my nonprofit causes, and so I have a separate reason to be grateful for these incentives. But the larger public reason for being grateful is that that incentive system is what enables the Court of Chancery to have the diet of cases that contribute to public learning about how business ought to be conducted. So the next slide, much more quickly, will review the benefits of this system. And as I've said, basically, we're talking about a system in which the courts convey a set of rules that will guide business planning, transactional planning, improve predictability, and do so in a way that balances the cost of a litigation-based system, which are substantial costs, with enhanced commercial confidence. And that system is one that has been known to fail on times, but overall works very well. I thought in the time remaining, as we'll see on the next slide or two, I'll give an example of how this system has worked, and in particular, how it has governed mergers that are accomplished by controlling stockholders, usually where controlling stockholders essentially forcibly buy out the minority's stockholders' shares. Going back to the year of my birth in 1952, there has been traditional doctrine that says simply that where you have a transaction like that, a controller-stockholder transaction, that entire fairness standard applies. And yet, there was case law that said that disinterested stockholder approval by the minority, would restore that judicial deference associated with the business judgment rule. That was how we loosely understood the law until 1983, when the Delaware Supreme Court decided the very well-known case of Weinberger versus UOP. And by the way, the University of Pennsylvania Law School has a website that contains oral histories of some of these cases. And in the next month or so, we're going to be releasing a documentary video about the UOP case, told from the perspective of people who were involved in the case. It's been a very interesting project, and there's some other famous cases that are the subject of documentaries. But the UOP case restated the entire fairness doctrine, but made a suggestion that maybe the result would have been different if a special committee of disinterested directors had been charged with negotiating with the controlling stockholder. Well, it didn't take practitioners long to, and they started to create these special committees in such transactions. And the question was whether or not the use of such committee would restore the business judgment rule, deferential review. 12 years later, the Delaware Supreme Court decided a case called Kahn versus Lynch, which had resolved a previous split in decisions within the Court of Chancery. And it said that, yes, the special committee process will shift the burden of proof, but it doesn't restore the business judgment rule. You still have to decide whether or not the trend was fair. In other words, you have to go through discovery. You have to go through a full-blown trial. There's still uncertainty. So it didn't really accomplish much, the special committee technique. And during the 10 or 15 years after Kahn versus Lynch, there was this well-known, I'll just call it an abuse. The Court of Chancery called it a kabuki dance at one point, where plaintiff's counsel would see that a controlling stockholder was proposing a freeze-out merger, would bring a lawsuit even before the special committee did anything, and then when the special committee negotiated a bump in the price, the plaintiff's lawyers would take credit for it, and the defense lawyers would say, sure, we'll give you credit as long as we get to dismiss the case without going through all this discovery and trial. And so plaintiff's lawyers were getting very substantial fees for essentially doing nothing. And it's kept happening over and over again because there was really no good way to follow rules and get rid of or prevent litigation like that at the outset. And this generated some significant academic criticism and some rethinking from opinions in the Court of Chancery in the CNX case and Cox Communications cases in 2010 and 2005. But this all came to a head a few years later, and now for the next slide, in a case called M&F Worldwide, or MFW, where the Court of Chancery and the Delaware Supreme Court engaged in what I think was a classic example of Professor Enriquez's model of how a court ought to behave. The court took stock of all the past doctrine and said, what kind of doctrine do we want to create that will actually encourage people to behave in the right way and will minimize the bad impact of litigation while preserving the good impact? And what the court did was say, if you're a controlling stockholder and you want to do a freeze out, what you ought to do is use both a special committee of disinterested independent directors and seek the approval of disinterested stockholders and condition your unwaivably from the beginning on both approvals. In other words, each group, each independent disinterested group will have a veto. And because that most closely resembles the requirements applicable to arm's length mergers, that will restore business judgment rule protection. And the transactional effect of this ruling has been exactly what the Delaware courts predicted. Those who have been planning transactions like this have said, okay, except in rare circumstances where there is a contentious stockholder with a large block, the planners will say, sure, let's have both a special committee and a disinterested stockholder vote and avoid litigation, avoid expensive litigation, avoid an expensive settlement with plaintiffs' counsel who don't really contribute anything. Let's let these private mechanisms work. And this is a classic example of how the development of common law has brought with it a refinement in how the spectators to that system behave. Those who never have to bear the costs of litigation and the court system nonetheless benefit from it because they've been guided by decisions that emerge from the judicial system. And that goes back to establishing the basic point I made about corporate law and corporate law enforcement being a public good. And with that, I'm happy to yield my last 2 minutes to any number of questions that we can get in. And thank you, Jose Miguel, again for the opportunity to be here.
Thank you, Larry, for that wonderful presentation. We do have a couple of questions. I'll start with an easy one. The question has to do with the entire fairness test. So as we gathered from your presentation, no one wants to bear the expense and the time of going through discovery and the full trial. But that in practice means that entire fairness is a difficult process. So how does it work in practice? Who actually bears the burden of proof if the defendant has to show that a transaction was conducted under entire fairness? Is it the controlling shareholder? Is it the company itself? How is the burden usually met? I mean, just give us an idea
Sure.
of work in practice.
Yeah, I'll give you an example. The entire fairness burden rests on the proponent of the transaction, where we're talking about a freeze-out merger, it would be upon the controller and the controller's representatives on the board of directors. They would have to establish the fairness of the transaction. But it's not impossible. There was a case, I'd say about 10 years ago, called Trados, where the preferred stockholders controlled the board, and they implemented a merger which resulted in the common stockholders receiving nothing for their shares. Of course, the common stockholders were not happy about this. They brought a class action, and after a long trial, because entire fairness was the governing standard, the Court of Chancery said, you know what? The common stock, under the circumstances, was in fact worthless, worth zero. So the transaction was fair. It was not done well. Procedurally, it was ugly, but it was fair. But the proponents, the preferred stockholders who controlled the transaction, had to go through all kinds of burdens, costs, years of litigation to get to that result.
Right. Thank you. And one final question, because we've run out of time. How do you pick chancellors for the Court of Chancery in Delaware?
Great question. The chancellors are appointed by the governor of Delaware, but the governor of Delaware relies on something called a judicial nominating commission, which is composed of lawyers and non-lawyers from the community who review the qualifications of various judges and typically send the governor 3 names when there is a vacancy. Where the political balance requirement applies, they'll of course pick a Democrat or a Republican, as the case may be, or names of Democrats and Republicans. The governor is also very thoroughly advised by people who are familiar with the courts and the law in Delaware, and has managed to make a very good record of creating or picking judges who are hardworking and experienced. And if they aren't experienced when they start, they get it very quickly once they get there.
But is there a track record requirement? Like, you have to have practiced for 20 years before you can? Oh, right.
No such requirement. If there's actually a very funny video on that website I mentioned of an interview with the judge who decided the UOP case in the Court of Chancery, Grover Brown, and he describes for about 10 minutes about how he became a judge. He'll be quick to say he didn't know anything about corporate law when he started, but he learned very quickly, and I can vouch for that personally because he was hardworking and practical and thoughtful, and he more than made up for his lack of sophistication before he got to the court once he got there.
Okay, Larry, thank you so much. We've ran out of time, but thank you, Amir, and thank you, Luke. I see you're still here. It was great hearing your opinions on this matter, and then I'll switch to Spanish to announce next week's event. Thank you all so much. Bueno, pues muchas gracias a todos por su participación y por su atención. Recuerden que la próxima semana, el miércoles, comenzando también a las 8:15, tendremos un grupo de practicantes, de litigantes expertos que litigan con alguna frecuencia ante la Corte de Cancillería de Delaware, ante el Tribunal Especializado de Tel Aviv y ante la Corte Especializada de Ámsterdam. No se lo pierdan, nos vemos en una semana.